Everyone, thank you so much for your patience. Tonight I'm here once again to continue the Legal Hour program. And I'm so proud that most of you are joining us tonight. We have a commitment to bring you the legal update. So tonight, as I do always, I'm going to take my time to bring to you update of the law. Last week we had a very interesting program looking at those of you who have licenses and how you can remain compliant as a skilled worker license holder. So last week we looked at employers who have licenses, how they can maintain those licenses by ensuring that they are compliant with the Home Office rules and regulations or the conditions of those licenses. But tonight I have something quite unique and different. This time I'm going to look at how you can have the opportunity for your adult dependent relative, mainly parents, to join you in the UK. So I'm going to take my time to look at those who are eligible to have their parents to join them as adult dependent relatives. And more importantly, look at other dependent relatives who themselves are not parents but are also eligible under the scheme to join their sponsors in the UK. And I'll look at this broadly by looking at the definition of what a dependent relative is. And look at the requirements for satisfying the financial requirement. And above all, the tool in your armory, Article 8 right. And most times when we are in the tribunal, it's so interesting that when everything has failed, you still have your Article 8 right, which is right to private and family life under the European Convention of Human Rights. And it's so interesting why you can rely on it to make so much headway under the immigration rules. So tonight I'm going to take my time to explain all these things. And I'm going to do that within a couple of minutes. I won't take much of your time. But also, before I even go into that, I'm going to look at the statement of changes. You know, most times, as a practicing immigration lawyer, you need to update yourself with the law because Home Office is always coming out with what they call a statement of changes. It means that they are changing the laws, they're changing the immigration rules, and therefore you need to be abreast with these changes because otherwise you are likely to make a lot of mistakes and then clients end up suffering for those mistakes. So tonight I also look at some of the changes in the statement of changes that was announced on the 9th of March. And then after giving you this free update, I go straight into looking at how parents can join their sponsors, which is either their children, adult children here in the UK, and those who want their dependent adult relative to also join them, how they can also do that. That's what I'm going to look at broadly tonight. But as I do always, I want to invite you to invite a friend to invite a friend. Obviously, this program is being broadcast on various channels or platforms. You can watch this program on CITI Media TV on Facebook. On Facebook, you can also watch it. My own personal profile, Thomas Bebon. I always urge you, those of you who have been watching it on my personal profile, to move to CITI Media TV Facebook because that is the epicenter where all the action is happening live. So please, migrate from there and join the CITI Media TV. But that notwithstanding, you can also watch it CITI Law Solicitors Facebook page, So it's being broadcast live there as well. We also have the YouTube channel, City Law Solicitors YouTube channel. Those of you who don't want to watch it from Facebook can also watch it from there and share it with your friends. So, as I do always, I'm going to go on a short commercial break to give you the opportunity to share the links with your friends, because I'm also going to do the same. So we can have a community which is going to be full of knowledge, because knowledge is always power. So I don't want to go away whilst I go on this commercial break. But it's also an opportunity for you to look at all the various areas of law that we practice. So as well, listening to music and dancing to the tune, you also keep your eye on the areas of practice which City Law Solicitors brings to you every Tuesday and Wednesday evenings. So please don't go away. Hello, thank you for your patience. I'm quite grateful for this opportunity to be here once again. Um, so as I said earlier, if you have just joined me tonight, I want to announce that I will do this program every Tuesday from 9 p.m. I'm a bit late tonight. And then on Wednesday, we'll do it in three languages. So tonight I'm going to do the English session, and then on Wednesday, the famous MC Chaka will be here for us to do the Tree section. Tonight, I'm again looking at immigration. I'm looking at how adult dependent relatives can join their sponsors. I mean, those who are here that want their parents to join them here because they are back home, they are vulnerable, they need personal care, they need that help, they need that assistance, and they don't have to be wallowing in sickness and be so vulnerable without having anybody to care for them. And also, obviously, if you have adult dependent relative, which is your brother, cousin, and there is a need for that person also to join you here. Those are the areas I'm going to look at tonight. But before I do that, I'm also going to look at the statement of changes. Normally, Home Office announces statement of changes every now and then, mostly quarterly. So in March, on the 9th of March, there was an announcement which brings to bear a lot of changes in most of the immigration rules, one of which I'm going to discuss tonight. And there are numerous of them, which means that obviously you need to be quite abreast with it, because otherwise you'll be relying on the old law, and that law in fact has changed. And most of them, some of these changes, that's what they call an announcement of statement of changes. Some of these changes might not take place from the 9th of March when the announcement was made. Some may even take place in November 2023. Some may take place even the following year. Some will take place in June of this year. So, but you need to be familiar with these changes, because obviously these changes are going to bring to bear paradigm shifts of the rules themselves. And tonight I'm here to just take you through a few of them that I think will be quite relevant to most of you who are watching me tonight. Then from there I will go to my main topic. So I'm just going to spend just a few minutes to discuss the statement of changes announced on the 9th of March, and then straight away I move into my topic, which I'm going to spend most time to explain to viewers how they can assist their adult dependent relatives to join them in the UK. Now, so on the 9th of March, Home Office announced changes that are coming to take, some of them are taking place in November, some are taking place in June. Now, you find out that the EU settlement scheme is still ongoing. The late applications is there indefinitely. The new change is that if one made an EU settlement scheme application and one is refused on suitability grounds, in most times, for example, where one has submitted forged documents or one has some criminal offense, then in most cases, that person will not be entitled to administrative review. So, mostly when applications are refused, applicants are entitled to what they call administrative review, where they make submission to the Home Office to review their decision on the basis that there is an error in coming to that decision. And so if you are refused on suitability grounds under EU settlement scheme, you will not be entitled to that administrative review. However, you will still have your right to appeal. And I'm sure that the reason why most of these changes are coming, because there is huge backlog of administrative review that are pending. We have had clients that we had their administrative review pending for almost 2 years now, more than a year. And each time they want an update, and I keep reminding them, look, there is no update. So obviously, if you were refused on those grounds, you can now no longer do administrative review as EU settlement scheme applicant. The other point is that continuity of lawful residence. Normally we know that when people have lived here in this country continuously and lawfully for 10 years, they are entitled to indefinite leave to remain. Now, the rules have made it clear that if you have any leave, which is a year or less, that you cannot switch it, then that stay will not contribute to your lawful residence, which means that visit visas for people who are living here on visit visas, then that leave might not contribute to lawful residence. That is one of the statement of changes. And returning residents. This is quite rare, but sometimes people forfeit their British citizenship. Now, when people forfeit their British citizenship, automatically they lose their indefinite leave to remain. And once that has happened, most of those people, if they want to come back to the United Kingdom, then they come back as under the category we call returning residents. Again, I remember many years we dealt with a client who had indefinite leave to remain in the UK and then lived in America for a long time. And then he eventually came on a visa for some time. And when he decided that America was no longer conducive for her, he wanted to come back home to the United Kingdom. And we made application for her. It was established that she had had a visas before. She has lost the indefinite leave to remain, and she was not entitled to make the application from the United Kingdom. And therefore, we have to track this case for so long. But the good news is that he was eventually granted. Now, to cut a long story short, those of you who now want to come in as returning residents, the good news is that if you have your indefinite leave to remain has lapsed, either because you have renounced your British citizenship or you have left abroad for more than 2 years and your indefinite leave to remain have lapsed, and then you decide to come maybe for a quick short-term visit. In the past, that would have been used against you, but now, even if you came in during the intervening period before you apply as a returning resident, if you came in with a visa and eventually go back and decide to apply from abroad to come to the UK, to come and live here, or to get your indefinite leave to remain back, you will still be eligible to do that. So these are the few changes that I feel. There are numerous changes, but these are the few ones that I feel that they are quite relevant to most of you watching me tonight. So having announced some of the, or explained to you some of these changes that have been announced from the 9th of March in the statement of changes by the Home Office, I now move straight into my main topic. Now, if you check the screen, you see that my main topic is the new immigration rules for bringing parents to the UK, to join you in the UK. Now, normally, when I say parents, I am talking about parents who are reliant on you, who are adults, who are your own biological parents. So I'm going to take my time to explain some terminologies here, because normally when we talk about adult dependent relative, we are talking about people who are our relatives. And those relatives mainly can be our parents. But remember, they can also be our siblings. But they are adults. So in most cases, when people want children to join them under the immigration rules, they should be 18 years or less. But again, we have managed to bring people here who are more than 18 years to join their parents here. Who, when I get to this Article 8, I'll take my time to explain the magic, how people are still able to do some of these things under the immigration rules. So, to narrow this topic to parents, because I've already explained that these other dependent relatives includes siblings, sister, brother, and people that are mainly dependent on you. But for tonight, I'm just looking at the parents aspect. again, this is also an area that there have been announcement under the statement of changes that was announced on the 9th of March. Now, previously we had these rules, these adult dependent relatives imbibed in the Appendix F of the immigration rules. Obviously, when you look at it, there is a broad heading, family migration, under the Home Office policy. Now, this has now changed. So now we have a separate, stand-alone immigration rules for adult dependent relatives, which is separate from that of the Appendix FM of the immigration rules. And this is coming into effect this June. So this adult dependent relatives route here, there are requirements that people need to satisfy in order to be able to, because I'm just dwelling my topic on parents, in order for their parents to be able to join them in the UK. So I'm going to look at broadly 3 areas of these requirements and how people can satisfy them and how these applications can be successful. Because in most cases, if you don't meet the Home Office requirements, then the application gets automatically refused. And the difficulty of the entry clearance applications is that most times, if those requirements were not met and they were not before the entry clearance officer or the entry clearance manager, then even being successful at the tribunal is even more challenging, because you have not given all that was required to the entry clearance officer. So why are you running to the tribunal as a last resort? So that is why most of these applications need to be well managed, all the documents well prepared and submitted, so that if Home Office dislike you and decide to refuse it, then obviously you know that you have met the requirement. And it's for this reason that most cases are successful at the tribunal. So, in most cases, the starting point that people will want to understand is that who is adult dependent relative, specifically for parents. Now, the word dependency is quite broad. So within these rules, when we say that someone is your adult dependent relative, it could be a cousin, friend, a brother or sibling. But for parents, they are those who are your biological parents, and they are dependent on you because of, one, their age. Age is so significant here. That is the first factor, their age. The second factor is because, for example, of their disability. And the third factor is sometimes looking at their vulnerability. So you see that the age factor, normally if, for example, your parent is above the pension age, then that age factor becomes so significant if that parent was to come here to join you. Or he has some form of disability. Or that parent is vulnerable. And the other point is that that parent is not in a subsistent relationship, either with your own biological father or married to another person, unless both parents are joining you in the UK. So in this case, if you, most times our women, they want to bring their mother because they are so much in love with them, but their mother is in a subsistent relationship with their father. So in most cases, under the rules, you cannot bring your mother to the UK as adult dependent relatives, even based on her age, if your father is going to be left behind. The rule does not permit that because they are in a subsisting relationship. You are breaking their human right. The loving relationship that they have back home, you want to destroy it. So the rules have been drafted in such a way that it doesn't permit unless you are bringing the two of them together. The other factor of looking at this dependency is the fact that you should also go beyond the age to demonstrate that they require personal care, or that parent require personal care. And that personal care, one is either unaffordable. So for example, there is a care home in Ghana or in Nigeria or in Cote d'Ivoire where your mother can stay because of her disability or her age, but it's unaffordable looking at the cost of maintaining her over there compared to your own income or your earnings in the UK. So that maintenance is unaffordable. That is in itself is an advantage for that parent to join you. The other factor is when you take out the unaffordability, there is also no other person to provide that personal care. Again, here you find out that if you have siblings living where your mother is living, and your mother is not living alone, then even if you are sending £1,000 to your mother for her personal care, it means that there is somebody else there, one of your siblings, who is taking care of that adult dependent relative. And therefore the rule will not permit you to bring that person here. Because even though they are dependent on you financially, there is other siblings who are equally providing personal care to that vulnerable or disabled or aged parent. So you realize that in most cases one have to prove that that adult dependent relative requires personal care. Now let me give you an example. Most of you who are doing domiciliary care or working in the care homes, when we say one needs personal care, it means that you guys go out there to their houses, you either wash them, you assist them to take their medication, you also assist them to wash their clothing, sometimes you even take them out to do their shopping. So you are providing that personal care. And therefore, if your parent is in that situation, whether either the two of them or one of them who have survived the other because one is deceased, then because of the fact that you need to provide that personal care, and either because it's unaffordable in that country where he's living, or there is no other person to provide it, then that in itself means that you have satisfied the adult dependence rules. So that means that you have satisfied the first hurdle. The second hurdle is what normally will be called the financial requirement or maintenance. Now I need to be careful of my choice of words here because there are two distinctions here. When we're talking about financial requirements, it applies to those who want to bring their children and their spouses. They need to meet some form of financial requirements, depending on whether they are bringing children and spouses together, or just children, or bringing spouses alone. Then there is financial requirement, or bringing children separately. There is maintenance. So here there is maintenance. So when you want to bring your parent, you are not meeting financial requirement, as most of you get terrified because you feel that you won't meet it because you are not earning 18,600. No. Here, the requirement to be satisfied here is what they call maintenance. And the advantage here is that the assessment of maintenance is quite different from the assessment of financial requirement. The assessment of maintenance, because I've already explained that you need to demonstrate that that parent requires personal care, there is no other person to provide that care, or your means of income is such that even if you can pay for that service, it's unaffordable. So you meet these two conditions. Then you need to also satisfy what they call maintenance. The purpose of the maintenance is that, yes, we are going to allow you to bring your mother or your father or both parents to come to the UK. But you must demonstrate to us that their existence in this country will not be at recourse to public fund. Again, to explain this word, it means that when you bring them here or you bring your parent here, you must be able to show that you have the income, the means, the finance, the earnings to take care of them from your own pocket without running to the HMRC or the benefit system to provide for that mother. In fact, in most cases, as I'm gradually driving to some of these requirements, you find out that people are sometimes meant to sign undertaking that the first 5 years of their parents' arrival, they will not be able to claim benefit, or they will not be entitled to public funds. And we are in breach of that. I remember one of these days, one of my friends' mother came, and he called me, Joe, mother is here, can you claim benefit? I said, you know very well that for the first 5 years, even though your mother has been granted indefinite leave to enter, that's the good thing. They get indefinite leave to enter straight away. But they are not entitled to benefit for the first 5 years of their stay in this country. So it means that for the Home Office to assess that they are not going to be a burden on the state, they need to meet a maintenance requirement. Now, how do we assess the maintenance requirement? The assessment of the maintenance requirement is by looking at all the sources of your income. Again, sources of income is different from sources of earning. So looking at the sources of your income and then making deduction of your housing or accommodation and your national insurance and income tax. So when these deductions are made, then whatever income that is left for the family should be sufficient or at a level equivalent to anybody who would have claimed income support or job seekers allowance or whatever, which I understand is around £84 a week for those who are more than 25 years. So let me do a little bit of mathematics here. So in this case, even your child benefit is a source of income. Your universal credit is a source of income. Your working tax credit is a source of income. Your disability allowance is a source of income. So all these categories of even state benefits that you are receiving, they are all sources of income. So if you are working on part-time basis and you make some earnings from employment, it's also a source of income. So you realize that some of you are even claiming housing benefit. Now again, you realize that sometimes you are renting, you are paying about £1,000 a month to the landlord, and government is giving you, let's say, £500 to support you to pay your housing, your rent. So that 500 you are receiving from government, from public funds, is an income. So if you are to assess the maintenance, then we will take into account your housing benefit, or whether if you are not receiving housing benefit these days, most of you will be on universal credit. So when we take all these incomes into account and we deduct your rent, which is your housing cost, your national insurance contribution, your income tax if you are working, which means that once we have taken out your national insurance and your income tax, we are left with your disposable income. So maybe you are working, you are earning, let's say, $250 a week. And then once you have paid your national insurance and your income tax, you are left with disposable income. So that is also an income from your earnings. So you can also add that to your housing benefit, and in the end, you take out your housing cost and the national insurance and then the income tax. So that leaves you with your disposable income. And it means that if that income is equivalent, whatever is left to maintain you, is equivalent to the income support one will receive if they are not working. So let's say in the end, you have one child and you end up being left with, let's say, about £400 after making all these deductions. It means that the money that should have been available to the family if they were not working at all would be that maybe £84 times 3, that would have taken you to about 252. Correct me if my mathematics is wrong. Which is 80 times 3 is 240 plus 4 times 3 is 12, so £252. So you realize that such a person meets the maintenance requirement. So you see that the maintenance requirement is so low to settle, to satisfy. That allows you to bring your mother or your father or both of them to join you here as adult dependent relative, because you don't need to meet financial requirements. I know I bored you slightly with my mathematics, but it's important that sometimes I take my time to explain most of these things. So if you have just joined me, I have taken my time to explain the dependency aspect of the requirement. I've taken my time to also explain the maintenance requirement in bringing your adult dependent relative, and I'm mainly looking at parents this time around. At this point, I want to take the opportunity to acknowledge the viewers because most times I'm so glad that most of you join us up here. I have Level Gilbert, I have Amotados Kwasi, and I have 7 others. Most times this does not allow me. I have Cynthia Akuma, Cynthia who is also watching tonight. I have Abigail Asad. Abigail, congratulations and thank you for always joining us here. I have Thomas Ashama. Thomas, hello Thomas, I tried to get to you seriously, but you know I feel Thomas, please let me know when to get you. We're discussing about my children, please. Thomas, you know where to find me. All right. So I have Sophia Sean, very educational program, learning a lot. Thank you so much for joining us. Wow. I have Emanuela Mensa, who is also watching tonight. I have Azek Nuru, who is watching tonight. Guys, if you are watching me, you want to be acknowledged, you put a comment, because I can only acknowledge those who are watching and have put comments there, because I can see. But I can see that most of you have joined us tonight. This program might not be relevant to you today, but somebody out there might need to bring their vulnerable parent, who needs them to. And sometimes people think that there is so much to do. Now, by taking my time to explain the maintenance, you realize that even if you are not working and your income, after taking housing costs and national insurance, is like that what is left is equivalent to somebody who would have received income support of £84. You can still bring your parents to join you. And obviously, the reason why they take housing costs into account, because once you can pay that and there is accommodation for them to living when they come and join you here, then of course you've met all the requirements. But this has now become a stand-alone immigration rules, separate from the appendix. That's why I'm taking my time to explain this tonight, because this is one of the changes that were announced on the 9th of March, which is coming into effect the June, which is almost 3 months away. Tados, I think I've already acknowledged you. I have Rhoda Osei Ameya. Say thank you, lawyer. I'm learning a lot. Rhoda, thank you for also joining us. And Nuro, I think I've already acknowledged you. I think there's some of you who are watching for my personal profile. Most times I forget to acknowledge you because I've always said that I want most of you to migrate and then come to the CITI Media TV, which is where all the action is taking place. So guys, I'm going to continue the discussion. I have looked at I've obviously looked at the relationship requirement. I've looked at the maintenance requirement, and now I'm going to look at another tool in your armory, which is always the trick for winning most of these cases, even in the tribunal. And that is Article 8. So that is going to be something that I'm going to take my time to explain because it's quite technical. But that's where most times when every requirement has not been satisfied, one can still rely on that. So in most times you might not meet the maintenance requirement. You might not even meet the relationship requirement. But you might somehow be able to meet the Article 8 requirement. And under those circumstances, Home Office or the tribunal has a discretion to make that ruling in your favor on the basis of your Article 8. So I'm going to take my time to discuss that. So if you have just joined me and I have looked at the relationship, which people you can bring, adult dependent relative, I've talked about siblings and all that, but I'm specifically talking about parents here. I have said that the age is one factor, disability, vulnerability, personal care where they cannot have that personal care or it's unaffordable or there's nobody there to provide it. I have looked at the fact that it's so simple to bring your parents because you don't need to meet financial requirements. All that you need to satisfy is just the maintenance requirement, and which is very, very low level of income to show if you want to bring any one of them. Now, the other factor, if for example, you don't meet the maintenance requirement, probably even the relationship somehow is in dispute, then we have what we call Article 8 of the European Convention. And in this case, we are looking at right to private life and family life. So, here, in most cases, because I have looked at the fact that you may have to show that that parent required personal care, that personal care is unaffordable, or there is no other person in terms of any of the siblings back home who can provide that personal care, and therefore you are saying that I want that parent, which is my parent, to join me here in the UK. But maybe you didn't meet the maintenance requirement because you are not probably working. Or even if you met the maintenance requirement, they might reasonably argue that she doesn't require personal care, and therefore she should not join you here. So in this case, the right to family life or private life dictates that if you are a mother, if you have been visiting your mother regularly, you form that family life with your mother, and he's living alone, and he might not necessarily even require that personal care, but there is that family life. And you are saying that I meet the maintenance requirement, I meet the relationship requirement, and he's also dependent on me because I send funds, and I visit regularly, so I have family life with my mother. And for that basis, if you deny me the right for my mother or my father to join me here, you are breaching our right to family life. Then in this case, you have put Home Office in a very tight corner. So two things then happen here. Then this is a right to be respected in a democratic society. And of course, UK is a beacon of democracy. So they must respect people's right to private life and family life. So normally there is then a separate assessment, which is to look at what they call the public interest and immigration control. So in this case, if I'm bringing my mother and I'm saying that I have this family life, I have 4-bedroom. When he's here, she's not going to claim benefit from anyone. And therefore, because we are living in a democratic society and you are supposed to respect my family life with my mother, then under those circumstances, he is not going to claim benefit. I am not going to claim benefit. And our right to family life needs to be respected, because that is the European Convention of Human Rights, which UK has signed up to as a treaty. And therefore, on that basis, even if that personal care requirement is not satisfied, you are still eligible to bring that parent to join you under Article 8. And I want to give you a practical example. There is one of our clients that we made application for the daughter. The child has turned 18, and by the time we're in the tribunal, he's almost 20 years. And Home Office case was that he's above 18, and therefore he doesn't meet the requirement as a child of a certain person. But this is how we won this case. Our client has been visiting this daughter. They form a family life. He has just bought a 4-bedroom house. In fact, he lives here with his partner. They are both working. So tell me, why shouldn't this child, even if he's 20 years, join the father here? Because even if you're looking at a public interest test, he's not coming here to claim benefit. There is a suitable accommodation that is available to this adult child. And in fact, the father has formed a family life throughout the period that he has been visiting this adult child. And if you look at section 117 of the immigration rules, it takes that assessment into account. In a case where it's not going to be at recourse to public fund, then of course, it is not against the public interest for even that adult child to join their parents. These are quite technical stuff that don't want to buy them, but I'm just trying to use this to illustrate how powerful this Article 8 right is, to the extent that even if you don't meet that requirement, which is what I've just explained in terms of the adult dependency, because you are mother might not need that personal care, or because of the fact that there is an issue with the maintenance, then there is always a recourse to Article 8, which then allows one to still be able to bring that parent under Article 8 rather than the immigration rules. So most times you have to note the distinction between the two, because otherwise you go to the tribunal and be arguing for one and forget about the other one that is so powerful, and you end up losing the case. And Home Office will encourage you to argue on one grounds so that they can dismiss your case. Right. So guys, it's been quite interesting to have you tonight. At this point, I'm going to open the phone lines. If anybody has any question, I'm well prepared to take questions. I always say that I am not a doctor to provide you with diagnosis. I'm not a pharmacist to give you prescription, but I know the law. And once I'm here, I'm always prepared to answer your legal questions. As long as that falls within my competency and my areas of practice, I'll be more than happy to answer your legal questions. So at this point, the phone lines are open. You can check the phone lines there. Whilst I'm waiting for anybody who has a question to ask, I'm going to advertise CITI Law Solicitors. They are our proud sponsors of this wonderful show, brought to you every Tuesday and Wednesday. So at this point, I'm going to quickly take you through some of the areas of our practice and where you can find us. CITI Law Solicitors is a law firm specialized in numerous areas of law. We specialize in immigration, which is what I've just been describing here. If you want to bring your adult dependent relative, your mother, father, that's what I've just explained to you. If you want to bring your children to join you, we can assist you. If you want to naturalize, if you have any EU case, if you have a case even you want us to assist with judicial review. Recently, we had one of the clients, we made application for the family member to come on a visit. And as Home Office will always refuse. They just refused the application. And then when I told the client, he said, you know what? I went quiet for a while. She called me a couple of times. She's given up. We launched just the protocol stage. And then within a matter of 3 months, I called her. I said, look, we got an email that your family member should go and call her. He said, lawyer, are you sure? I said, yes, I'm sure. And then within a matter of weeks, he went there, he just had a visa. So you see that most times when some of these applications are refused, there are so many remedies. But it's up to you to know the law. So if you have any immigration problem, don't go far. We'll be much willing and able to assist you with all your immigration matters. Employment law, if you ever been dismissed that was not your that was unfair. Unfair in this case means that you have worked with an employer for 2 years or more. Or if you have suffered discrimination at the work, bullying and harassment, if you're on maternity and you are being dismissed, if you're going to redundancy and you're not getting the employer to pay the redundancy, because most times they want to use it as a way to dismiss you rather than pay you redundancy pay. Our employment law team, we are here to also assist you. Family law. If for whatever reason you can't see your children, we can put in place child arrangement order. If you are being harassed at home, you are suffering domestic abuse, or you are a victim of domestic abuse, we'll be able to put in place non-molestation order, occupation order, if you are going through divorce and you want us to assist you. Guys, we can also assist you. Because most times when it comes to division of assets, the law that has been in place since 1973, so that law is like cake. And therefore there is a lot of discretion for judges to apply. And therefore if you are not properly represented, you go to that court. And the one that is represented will take all the assets and you come back home empty-handed. So that's why sometimes when you are dealing with all these divorce cases, you need a lawyer to assist you. And CITI Law Solicitors is a family law accredited. You can check it out. So when we are representing you, we are the apex of this practice. You can only get the best from CITI Law Solicitors. So that's one of the areas that we can also assist you. Personal injury and clinical negligence. If you ever had accident that was not your fault at the workplace, or motor accidents, you're in a car, you suffered accident, you had some whiplash, you have some injuries. If you went to the hospital, you had some surgery, they left some bandage in your tummy, they left some needles in your tummy. Those acts amounts to what they call clinical negligence. And sometimes they will try to remedy it for you, but hey, you are still entitled to claim. And therefore, we are also here to assist you with those legal issues. Commercial dispute and civil litigation. If somebody is owing you and doesn't want to pay, if you're a business, you want to put in place partnership agreement, shareholders agreement, directors agreement, all these areas, in as much as we may overlook them, when we start businesses, when the business mature and revenues are coming in, there is always a fight. And most times, people come to us, we can't assess, because you know why? The basics have not been fulfilled. You need to put all these policies in place, all these shareholder, all these partnership agreements in place, so that in the event that someone, the other party, want to be so greedy and take everything, you just drag that person to court, and the court will make sure that everything is divided according to your efforts and your contributions when you started the business. Housing law, if there is a disrepair, especially now that we are staying in winter, or you are being unlawfully evicted, we can also assist you. Consumer law, most of you who have had problems with insurance companies, you don't want to pay your claim, you've bought products, but one reason or the other, that product has become faulty. Hey, I always say that every product under the Consumer Rights Act 2015 has a minimum of 6 years lifespan. Throughout that period, there is always a remedy for either to reject the product first 6 months, entitled to repair or to reject. Within 6 years, entitled to repair or to reject and deduction for the use of that product. So in most cases, I know, I practice it. I have a TV sitting in my conservatory that was given to me for TV that I've used for many years. I exercised my right under the consumer law, and I was given a new TV. So I know what consumer law can do if you know you're right. Media entertainment, if those of you into media, people trying to defame you on social media, don't try it, because obviously you could be dragged to court and you're going to pay huge compensation. And somebody have tarnished your image on social media, Facebook, YouTube. You want City Law to assist you, we'll be here to assist you and go after that person. Any corner, wherever that person is. So guys, these are the areas that we practice. I always say that City Law Solicitors is one stop. This is where all your legal matters can be resolved. I've been waiting patiently. It looks like tonight I've not had anybody to ask any question, because it means that I have done a good job. So at this point, I'm bringing the program to an end. Tomorrow, MC Chaka is going to be here. Whatever I have discussed here, we're going to also do it in a Tree language. And guys, I want to plead with you to join us once again, because most of these things are quite helpful. I know many of you out there who have been following us for some time, you are avoiding most of the mistakes other people are still making, because they don't have the benefit of this free legal advice. I'm so proud to say that whatever we teach here helps a lot of people out there. And that's why we are committed as part of our corporate social responsibility to be here every Tuesday and Wednesday to educate the public so that they can know their legal right, because it's a legal choice. Every problem that we face in this world, apart from being medical, is a legal problem. Even deductions from your HMRC chasing you with underpaid tax is a legal problem. You need to know your right to say, no, this is wrong. So if you have missed any part of this show, you didn't join me from the beginning, I want to announce that this program, or if you find it very exciting and insightful, This program is going to remain on our platforms permanently, so you can watch it again and again and again, and you can also share it with your friends. You can also ask questions, and of course, in most cases, we can respond to those questions there. Before I go, let me check if there is any other person. I have Ike Ibe Peters and Nancy. Oh, Nkweli. All right, Nkweli, thank you so much for joining us. Nancy Nkweli, who has also joined us tonight. We miss you so much. We hope you come back soon so that we can have a wonderful time. Yes, I think I have Ni Abiashi. Please forgive me if I have not pronounced your name properly, but I'm trying very hard. I have Ni Abiashi. Thank you so much for joining. I have Patricia Nkosi Obi, Ezu Obi, who is also watching us. Patricia, thank you so much for joining us. Emmy B, I have Emmy B, who has also joined us. Gabriel Bankoli, say thank you, lawyer. Cynthia Kama, I think I've already acknowledged you. Abigail and Tados and Nancy have just acknowledged you. Thomas, you know where to find me. Every time I'm here, that's the time that you have not been able to reach me. Right, Thomas, so I'll be expecting your call tomorrow. So guys, I'm very, very grateful to all of you for joining us tonight, and I want to encourage those of you who want to learn the tree or want to follow us to join our tree session tomorrow. The same time, MC Chaka is going to be here. We are going to have a very wonderful show, as we do always. Thank you. God bless you.